Family members, friends, and sympathizers of Nnamdi Kanu, leader of the outlawed indigenous people of Biafra, IPOB, were left deeply disappointed on Monday when the Department of State Services, DSS, failed to produce Kanu for the resumption of his trial at the Federal High Court, Abuja. Despite the protest by Kanu's counsel, Ifeanyi Ejiofor, who accused the DSS of refusing to produce the IPOB leader and preventing his lawyers and family members from seeing him, the trial judge, Justice Binta Nyako, insisted that the case could not proceed in the absence of the defendant. The judge adjourned the case to October 21, noting that the annual vacation of judges of the court had commenced. According to her, the court will only reconvene at an earlier date if the prosecution obtained a fiat from the Chief Judge of the Federal High Court for the trial to go on during the court vacation. To discuss what actually transpired in the court on Monday and why the media was prevented from showing the proceedings as they unfolded, we're now being joined from our Abuja studio by Counsel to the IPOB leader, Ifeanyi Ejiofor. Good morning, Ifeanyi Ejiofor, and welcome to the Morning Show.
Good morning, Mr. Bati. How are you? Good morning, Mr. Bati. Good morning, Mr. Rufai and Dasua.
Yeah,
good morning.
Thank you very much for joining us. Well, I mean, you must have listened to my introduction. I don't need to repeat details that are already well known out there. But I know you have a story to tell. Tell us your story, and then we'll take it from there with regard to the trial of Nnamdi Kanu.
Mr. Bati, of us, we are fully aware, DSS of Nigeria has the history of gross violation of court orders. And the fact that Nnamdi Kanu was brought to court on 29th day of June 2021 without reference to we, as lawyers, that he was being taken to court on that day, the court made an order. Because the order for the court, for them to produce him in court on 26th of July 2021 for trial to commence, it's an order. So it's immaterial that court commence vacation on that day. They're supposed to have produced him in court. So they have a history of clear violation of court orders. Even in this case, I don't want to mention other cases on record. In this case, on 14th of October 2015, when Nnamdi Kanu was arrested in Lagos and brought to Abuja, he was taken to Magistrate Court on 16th of that October and granted bail by the same court. Then the VSS refused to obey the order granted admitting him to bail. On 19th, he was taken to Federal High Court. Adamola J also granted him bail unconditionally. That order was flouted. Then only for them to file frivolous and unfounded charge, 11-count charge against him on 23rd day of December 2015. So they have the history of flouting court orders. It's immaterial where vacation commenced on 26th. This was brought into court on 26th for trial, for commencement of trial. So, and also it's more so when the DSS has denied us access to him few days before the day for the trial of the case of commencement of trial. We made an effort to see him trial last week before the trial on Monday. They never allow us to see him. And it's fundamental that in a criminal proceedings of this nature, we should see, assuming the trial was supposed to go on Monday, it now means that we have no pre-trial conference discussion with our client before that Monday. So we are denied access to see him. And so this is what we are talking about. That was why we filed an application to get him transferred to prison custody. So where we have unrestricted access to him to apply for trial. So, and I want to put it on record today that application, though the court was insistent about getting that application because of the fact that because he said we're in vacation, but that application will be heard at next adjourned date. When heard, and the court must positively consider the application because we must have a forum to see him, interview him, and also before the trial commences. So it's fundamental that that application is considered in the positive to allow us to have access to him. Though an order was made on the 26th of July, court made an order based on my application, allowing us unrestricted access to him Mondays and Thursdays. And I'm in the hope that BSS will also obey these orders. So what happened in court on 26th of July, in summary, is not strange to us. It's very, very conversant with this political trial. We are used to it in 2015. We experienced it. We experienced a situation whereby Nnamdi Kanu, when we be brought to court, we look as if the president is being brought to court. A person has committed no offense unto law. So we are very familiar. But unfortunately, the treatment was extended to the media and also the lawyers who were locked up from courtroom. So it's unfortunate. And the lawyers, the courtroom is only the jurisdiction where the lawyers belongs to. I was surprised they were locked up. It took my intervention to ensure that many of them were admitted. Because when I came in, I was astonished in the first place that lawyers were locked out from courtroom. So I have to intervene to ensure that some were allowed in. So,
okay, Ifeanyi Ejiofor, we'll take a short break. When we return, the conversation will continue. Please stay with us. We'll be right back.
As you're watching the morning show here on the Rise News channel. Well, the Counsel of the IPOB leader, Ifeanyi Ejiofor, is still with us from our Abuja studios, the IPOB leader, Nnamdi Kanu. Thank you so much for staying with us, Mr. Ejiofor. Let's talk about that prayer that was denied by the court, the prayer to have him transferred to a correctional center. Is that solely because you're unable to access him to provide better counsel, or are there other reasons why you wanted him transferred to a correctional center?
You see, the point is that when a person is charged with criminal offense and the offenses of such a nature my client is charged with, he should be allowed access to his lawyers, also giving adequate time and facility to defend them. So, and we didn't think that the DSS is a convenient forum for him to be detained. So, and it is more so when DSS made it known to us that they've concluded interview. They call it investigation. So I don't know what is still in there. So they should allow him, they will transfer him to a place recognized by law where he's supposed to be for the trial, pending when application for his bail is considered. So because we are being restricted from seeing him in DSS facility. That was why we filed that application. And also, let me correct this impression. That application hasn't been had. Ordinarily, it's application grantable as a matter of course. So I just mentioned it to the court because it was filed on 14th of July and served on the prosecution in the federal government on same day. So, and they filed a counter affidavit to this application on the 16th, 48 hours after receiving being served with application. And they withheld it for the reasons best known to them. They didn't serve us the counter affidavit. Until on 26th morning, in court, they ambushed us with the counter. So I only mentioned to the court that look at what transpired, because they raised issues in their counter affidavit which you need to address by way of further affidavit. So to ensure that the court hear it on the merit. So, but I mainly brought to the attention of the court, my lord, that application to be for my client to be transferred to prison is grantable as a matter of course. It didn't need a formal application to that effect. But because of the nature of this case, we have to go by a way of formal application, wherein we have to bring in laws, bring in the laws and facts that will necessitate the consideration of the application on the merit and possible granting of the application. So it was adjourned for consideration to next adjourned date. Of course, here where the court asks either the prosecution or we, defense counsel, to come up with an application for fiat to enable him entertain the case during vacation. So that is the position. We are not comfortable with him being detained in DSS custody while the trial commences, and I will object to it and I will oppose it, because that is not a place will be. You may be surprised to hear that during the last visit, one of my colleagues, during our last visitation to him, one of my colleagues was harassed by DSS. And they will call you to come to that place, because when you apply to see him, they will give you a convenient time convenient to them, not convenient to us. They may ask you to come 6 o'clock in the evening, 7 o'clock in the evening, or come on Saturdays. So I don't think we're going to work with that kind of guideline. And if you go there by 6 o'clock in the evening or 7 o'clock in the evening, you end up leaving the premises around 9 o'clock and 10 o'clock under clear case, under intimidation. So, and one of my colleagues was harassed. I don't want to make it public, but I'm saying it. So we cannot effectively defend him while in DSS custody. So we are going to oppose it. He must be transferred to prison custody. So we are going to address it in the fullness of time because we are going to file a further affidavit to that effect and get it argued on the merit on a non-adjourned date. So thank you.
All right. So I'd like to ask, you say you've not been getting access as you should get. When last did you see Nnamdi Kanu? Number one, what was his state when you saw him? Two, I also like to ask you, have you been able to now go one step further? Because there was this clause about the judge not being a vacation judge, to file that fiat. And thirdly, there were some IPOB members arrested, that day on the 26th that he was supposed to be in court. And I remember, I think it's our political editor, our chief political editor, Somna Sambo, that was telling you while you were, granting the press audience that day that some members were arrested and you didn't even know about it. What's the state with those people? What's going on? Have you been able to intervene in their case and what were they arrested for?
Well, some of them, after my interview and also possible appeal to the security agents, some were released. So we have a minimum number of them still in detention. Now we're following up. I've already made a contact with CP, FCT to ensure they are giving them, they are released unconditionally. And we are going there this morning to follow it up. So, of course, you know the way and manner they behaves. These people, court is a public place, accessible to the public. And they never conducted themselves in a manner that suggests they are violent. They were just there to observe the proceedings of the court. But what happened before the court is a matter of serious concern to the public and to the world. You see, there's as if there's a war going on, battle going on, shooting all over the places, intimidating people. So, obviously, if that kind of atmosphere continue to be witnessed in any time the matter is adjourned for hearing, that means there will be no fair trial. Because the same federal government prosecuting Nnamdi Kanu is also chasing fly away from the court from observing the proceedings of the court. While we are restrained from coming to the court. So it's a matter of serious concern and we are taking steps because as I speak to you, international community is following up. They are watching on what's playing out in court. I don't want to mention them. It's a matter international community is following up. The American government also has, they are following up. I don't want to mention the foreign government who are interested in the matter. But I can assure you that the foreign government is following up. And we are briefing them daily on what's transpiring in court. So it's no longer business as usual, where people's rights will be grossly violated and they will go unchecked. So we are taking steps to ensure that we will keep the world abreast of what is playing out there. Coming to the issue of people arrested, I was also informed yesterday that people who came for the trial, who came to witness the trial also, we are arrested in Kogi, Lokoja, so by military. And they're being detained today, about 30 of them. They were arrested yesterday and still being detained as I speak to you at this moment. So we are still also following up on that. And I'm appealing to the security agency to prevail on the chief army staff to direct people to release my people. People who were in court on that day. People who merely came to observe the proceedings and cheer out their leader. So they should release them because they didn't come to cause any form of havoc or violence during the proceedings. They were arrested yesterday on our way going back to the east at Lokoja. And they are still being detained in Lokoja military barrack today.
Counsel, what are your next steps? Is it possible for you to outline your next steps for us? It's clear that your client will remain in custody.
Okay, thank you so much.
October. What are the next steps that you intend to take? If you could just outline them for purposes of clarity.
We have taken steps to apply to the Honorable CJ for fiat because the court gave us a window that either the prosecution or the defense counsel will also apply. We have done that, and I know they will not apply. So we applied and waiting for approval from the CJ. In that regard. So, and also, in line with the substantive order of court, that we should see him on Mondays and Thursdays. I already informed the public that I'll be going to see him tomorrow at 2 p.m. So, I understand that the ESS will have made communication with them, refuse to reply our text. But I will go there tomorrow by 2 p.m. So, and whatever outcome, I will make it public. So, because we can't continue to live this way. So, if they don't want to try him, they should let us know. That's the position. Waiting the approval of the CJ for an application to grant fiat to the honorable court to hear the matter during vacation. That's what we are waiting for. And it's more so when my lord are expressing stress to entertain this charge during the vacation. So, and it makes it more easy for us, because if the Lordship is not disposed to hear the application, to hear the suit during the proceeding, the vacation, to have been a different thing altogether. So that ground enough, I believe the CJ will consider application on the merit.
Okay, that's the.
But also, let me correct this impression. I find it very worrisome, because severally I've heard you over the media, and also I watch you, we follow you on social media. I also watch your programs most likely every morning, and I've heard you severally mention about Nnamdi Kanu arrest in Kenya. So, and it's important at this function. I find it a convenient forum to correct that narrative. And also, I believe this my position will influence yours too. I want to understand the fact that Nnamdi Kanu was never arrested in Kenya. So, what took place in Kenya was a clear case of abduction and kidnapping. So, I want you to let the world understand this part. He was not arrested. So, the issue of arrest never come to play. So, because if you compare what's happened to Nnamdi Kanu in Kenya and what is playing out today in Benin Republic, you see that Iboho was arrested and taken to custody where he's being subjected to trial. But Nnamdi Kanu was kidnapped at Nairobi airport, taken to a place, not even a police facility. Also, you may also be surprised to hear this morning that upon his abduction, within 24 hours of the abduction, people who are familiar, who are his friends, start looking for him. And they visited all the police facility in Nairobi in search of him. He was not seen anywhere. So, and he was detained in that private residence for 8 days. So that is a clear case of kidnapping. So after 8 days, he was now handed over to the Nigerian security agents who smuggled him here by external rendition. So what happened in Kenya is a clear case of rendition operation against Nnamdi Kanu, which is a gross violation of international law, which Nigeria and Kenya are all signatories to the treaty. Geneva Convention protocols, and also protocol against torture of persons. So, which we have already invited the international community, International Court of Justice, to investigate what transpired in Kenya. So, I don't want to go into the merit of that, but let me just correct that impression. So, the issue of arrest does not even come in the first place. So, I want to correct you to stop telling people that Nnamdi was arrested in Kenya. He was never arrested. He was abducted by rendition oppression. He was never arrested. So, if they have arrested, if he was truly arrested in Kenya, they were subjected him to the proceedings, the surrounding proceedings in Kenya. Then the world would know he was arrested. So what happened to Iboho? Iboho was arrested, and it was made known to the public that he was arrested. So he wasn't arrested. So let us correct that impression, because it's giving my people very serious concern each time you mention about arrest. And you can see me using word kidnapping and abduction regularly in my interview. So I'm not mistaken about it. So there's a clear difference between a case of arrest and also a case of abduction. So what happened to my client in Kenya is a clear case of abduction and kidnapping. So I want you to be reflecting it in your subsequent interview, please. Because I heard you yesterday telling the commissioner that he was arrested in Kenya. No, he was not arrested in Kenya.
Counsel,
thank you so much, Mr.
You well advised that I know the difference between arrest and also extraordinary rendition. Those are not issues that can be explained to me. But I know that, you guys have approached the African Commission on Human and People's Rights to specifically accuse the Nigerian government of abduction. Where are we with that?
Sure. No, we are waiting for the communication has already been sent to them. We are waiting for further directive from the African Union. And I believe we also filed a affidavit of urgency necessitating urgent attention to that correspondence. So I believe, and we're checking up. But I believe I should be more at home with the issue of abduction and arrest than you. As, with being fair, with all fairness to you. So I believe I should be more at home with that, what arrest amounts and what abduction amounts.
No,
so
I don't need any education
the word is
on
listening.
the subject. No, I don't need any education.
No, well, I'm a lawyer now. I don't think.
No, don't worry about that.
I'm an expert in this field, Mr. Mazi.
Don't worry. You are not in a position to educate me. Adesua, please.
Yes, Mr. Ejiofor, the last time you were on the morning show, you raised concerns over your clients getting fair trial. Can I ask you, do you think that your client is being tried in the court of public opinion? And are you worried that that may affect the outcome or the decision of the courts?
Thank you, thank you, Adesua. I thank you for reminding me this. Because the point is that what is playing out today, and this Nigerian government is conversant with that, is we are conducting what they call media trial. And we are good for, we are with them in that part. So I don't think we have a problem with that. We are doing what they call media trial. Of course, before the last agenda, before 26th of July, the world was informed by the Honorable AG that what will be seen in court on 26th of July, we're going to see a case of murder, terrorism, banditry, kidnapping, or whatnot. But I can assure you, I can confirm to you this morning, that on 26th of July 2021, we're in court. There was no new charge introduced to in this case. There was no any form of amendment in this charge. No form of amendment. So we are into what they call media trial. So, and we need to inform the public very well, properly. So there was no amendment to the charge. And you know, in law, you see who assert must prove. It's one thing for you to level allegation against somebody, as frivolous, unfounded, and bogus as they may be. But it's for us to come to the court and establish it. So the fact that you are saying that you are going to see a case of murder, banditry, kidnapping, and all whatnot, and in court we didn't see anything. So even the application will file in time, serve on them on 14th of July. We are not responding, we are not served on us in good time. Because if they had filed and served that application in good time, we have responded and possibly convinced the court to take the application on that day. So I am not averse to this kind of practice. We are very familiar with it. It's been on since 2015, and we are there for them. So they will first of all try somebody, particularly somebody with somebody who is standing on a political trial, or special interest, or media, and getting convicted. So I can assure you that 60 or 80% of uninformed Nigerians had already believed that Nnamdi Kanu committed a case of murder, a case of kidnapping, a case of torture. When there's no such cases, even in the court, there was no such charge in court. So it is their practice, and we are good with them. We are going to give them, follow the head on that part.
Okay.
Thank you. I'm not worried at all. So
okay.
Whatever they're saying, we're going to get it debunked in the public opinion.
Okay, Mr. Ejiofor, I mean, you didn't answer my question I asked earlier on. I asked about when last, did you
sorry, Mr. Ifeanyi.
Did you see Nnamdi Kanu? Because you said you've not been getting access to him. What was his state? I also asked you, I also have more questions. We'll come back after the break. We'll talk some more. Back. So we still have a counsel to Nnamdi Kanu, Ejiofor here. Ifeanyi, I was asking before two things real quickly because of time. Number one, the state of Nnamdi Kanu the last time you saw him. What's his health like? Secondly, Katrina Lang, British High Commissioner, yesterday said Britain will provide consular services. What's the talk about that? Have you spoken to the British as regards this? Let's talk quickly. Ifeanyi.
Thank you so much, Mr. Rufai. I'll be very quick about my response on this. So, on record, and also on record of the DSS, we visited Nnamdi Kanu last on 17th of July, 2021. That was on a Saturday. The Saturday, they asked us to come around 6 p.m. and around 4 p.m. And we were there till about 10 to 10 o'clock in the night. That was then the concluded interview with him. So that was last time we saw him. And at the time we saw him, he was still wriggling in pains of grievous injuries he sustained on account of the torture meted out to him during his detention in Kenya. And secondly, the burden of solitary confinement. Because when somebody is kept in a confinement where he has access to his relatives, friends, and well-wishers, where he cannot communicate with anybody. You know the burdensome. You know how it is for somebody to be kept in such an environment. And he's not giving much attention. So, and last week we made serious effort to see him. And also get him prepared for the trial that's supposed to commence on Monday this week. So, on 19th, we made a contact with the DSS department who are corresponding with us in this case. They refused to give us attention. 20th, something happened. 21st, something happened. 22nd, 23rd, 24th, we didn't see him. So, and we have to cry to the court and inform the court about the position of the DSS, that they refuse access to him. So that is the position as it stands now. But let me hope and believe God that the other court just made on 26th of July that DSS will obey it. Then secondly, I can confirm to you this morning that British High Commission or British government is not doing much about this case. I can confirm also to you that there's every likelihood of connivance in what happened in the fate of my client on the part of the British government. Because sometime 2015, Nnamdi Kanu was arrested in Lagos, a British national. I know what happened. I know, therefore, they met. I know how they were keeping in constant communication with me, how they were visiting him both in SSS, where he was initially detained, before taken to prison. They were there severally. Severally, every 2 days, they used to visit him in prison, in DSS facility, when he was being kept detained there. And when he was transferred to prison, they were going and visiting him regularly. At times, they will make sure they will call to confirm from me about his medical state condition, whether they were still with medical expert. These are things they did in 2015, 16, 17, before he was granted bail. But today, as at yesterday was 27th of July, 2021. A British national was arrested on 19th, was abducted on 19th of June, 2021, smuggled into Nigeria thereafter, and was taken to court on 29th. And these things happened to the knowledge of British government. And apart from that, we will not formally notify them about what's happening to his national. Because at the time Nnamdi Kanu was arrested in Kenya, he was arrested as a British national. He has already announced his Nigerian citizenship for 5 years or 6 years before now. So, and they are, yes, and yesterday being 27, the British High Commission is talking about offering consular services to Mr. Kanu. I wish I had opportunity of talking to him. I was asking the High Commissioner, why haven't you seen him since that time? Have they seen him? This is a pertinent question to ask them. They've not set their eyes on Nnamdi. They can't talk less of offering any form of service to them. Today, I can confirm that to you. So, and you can ask, at least Mr. Bati will observe from the question, the manner he answered this question, that they are talking about that the Nnamdi is not a serious issue they're discussing now in the educational summit going on in UK. That I have other serious issues they're discussing. So he just responded to you by way of passing. It's not a matter that taking serious as you may be expecting. But what I believe, and which we are activating now, is that they obviously need a force of law to assert the obligation to the international. Well, and we are doing that with our partners in UK are doing that.
Ejiofor, we're running out of time. We have just about a minute to go, but very quickly. One, I would like to ask you, how hurtful do you think the protests in parts of the southeast are to the Nnamdi Kanu case? Because yesterday we were told there were protests, particularly in Onitsha. And then secondly, I mean, the issue about, our lordship saying, look, she will not grant the transfer of, the accused person from DSS custody to Kuje prison. What do you think of that, considering the fact that the ESN and IPOB have been accused in the southeast of, freeing persons who were remanded in prison custody in the east? Whether that is true or not is for you to determine. And previously, also, your client jumped bail. Do you think that the court of Justice Ifeanyi considered all of this to take that decision? He's saying he's better off in DSS custody. Very quickly.
Thank you so much. Mr. Bati, in the first place, you have been misinformed. The court never entertained my application to get him transferred to prison. The court said he will hear the application and that's a done date. But when I already applied for him to be transferred to prison, the court said he will not grant it now. And I informed the court that we'll have an application formally before the court to get him transferred to prison. And that application will be entertained on the merit and that's a done date. That hasn't been had. So coming to freeing person from prisons and in the southeast, I don't think I'll say more to that effect, because the governor of Imo State, Hope Uzodimma, in several forums, has told the world that those who tampered with the prison facility in Imo State and police headquarters are not IPOB members. It's on record. You must have it with you. So, and that has to a reasonable extent vindicated on every allegations against them to that effect. He's told the world that those who were involved in that act were neither IPOB member, not ESN, or people associated with IPOB. I'm talking about the chief security officer of Imo State. He said it. So who am I to say the contrary or arrive at the contrary? So the court didn't say he will not grant the transfer. The application will be held on the merit. IPOB and also it's a mere speculation over the media about the safety, his safety in prison. let me say this to you. When Nnamdi Kanu was detained in 2015 in Kuje prison, you must have heard about prison break during that period. There was an attempt at prison break. But Nnamdi Kanu stood still at where he was being kept. And there was issue. He never bothered. And it was an attempt by Boko Haram then to invade the prison, to break the prison. It's on record. He was there. He was in his cell, comfortably, never made any effort to go. So make inquiry from prison authority. They will tell you that Nnamdi Kanu is a fine gentleman. He's a non-violent person. So that should be a facility where you keep. He's a person that have respect for rule of law and others. So it can never, not of such that will happen. And that's why we're insisting that application should be heard on the merits by court. And delivered only one word or the other. Because we have facts with us. We have his antecedents when he was detained in prison in 2015. And I can assure you that the court will be convinced to grant that application. And also, I remember last time you asked me about the superiority of Nigerian British passport and the British passport. I believe the present situation must have answered that question to you. Only a few days ago, President Buhari traveled to UK for medical tourism. So if Nigeria is working well, why is he going to UK? So I believe that question has been answered. I believe I'm not missing any of your question again.
Well, Counsel, thank you very much, Ifeanyi Ejiofor. But I would like you to go with this. We're completely neutral in this matter. We're not taking sides. We're a media house. And that's why again and again we invite you so that you can give our viewers, the benefit of what you know. But we're not taking sides. We're totally neutral. We have no, special interest beyond journalism
I hope so.
in the matter.
I hope so, Mr. Abati.
Well, I've just told you that is the situation. That is